Hello, everyone. Good morning, good afternoon, good evening, wherever you are in the world. Welcome to this week's edition of Facebook Live with Joseph and Hall. We're going to give you the latest and greatest updates on what's going on in the world of immigration law this week. And then we will, as always, answer your questions and take inquiries from you about your own immigration issues. And we're happy to do that. So who would like to start?
I can start.
All right. What do you want to talk about?
So I wanted to talk about two things today. So yesterday, USCIS announced that they're going to allow resubmission of certain H1B petitions if they had been rejected due to a start date that happened after. So first of all, these are H1B petitions from the fiscal year of 2021. And if they had a start date that was after October 1st of 2020, they will allow for resubmission of those. And this is because they had received fewer petitions than they were expecting. So they reserved an amount and allowed for registration into November. And so then once they thought about that, it didn't really make sense that they were still keeping that October 1st deadline as the start date. So they decided that they're going to allow people to resubmit those previously filed petitions up to October 1st of 2021. So,
yeah, to give you some background on this, it's actually our office filed a lawsuit on this issue, and that the issue is that the fiscal year for H-1Bs always begins on October 1st. That's the beginning of the fiscal year for Congress. It's also the date that they issue the 65,000 visas that are available. So what happened is that there was a lottery for those 65,000 numbers, and they conducted the lottery thinking that they had sufficient applications to meet the 65,000 number. And so all the petitions that were filed under that had an October 1st start date, which is great because it matches the start date on the LCA, which is what they got through the Department of Labor. Everything's good if you had an October 1st start date. The problem is after that, they decided they had more numbers. And that was well after October 1st. So by the time people filed the petitions, it was well into November. Here's the tricky part. The USCIS takes the position that the start date on the actual petition has to match the start date on the LCA issued by the Department of Labor, which was October 1st. So you would force employers into a position where they had to lie about the start date on the H-1B petition in order to match the start date on the October 1st. And you sign the I-129 under penalty of perjury. So you're forcing employers essentially to commit perjury in order to comply with their nonsense rules about the start date. And so we took that to court in a case called Acquia. It was a mass action filed on behalf of several different law firms. Unfortunately, we didn't get a decision because the USCIS agreed to reopen and approve all of those cases and accept them beyond the rejection date. I think as a result of that litigation, we now have this memo that allows that to be done across the board to avoid further lawsuits. So, so great one. Thanks for bringing that up. Another thing that you wanted to talk about, Ryland, was the Central American Minors Program. What happened with that this week?
Yeah, so this was a program that allowed for Central American minors from El Salvador, Guatemala, or Honduras to come to the United States if they had a parent legally living in the country under permanent resident status, or if they were covered under a temporary protection, such as TPS, temporary protected status, or parole, or deferred action. This was a program that was started during the Obama administration. Then during the Trump administration, it was put out of commission. Now the Biden administration has brought it back. And last week, it has been expanded to include more eligible parents for the minors. So it's now applies to parents that have they have a pending U visa application. So if you're a parent from El Salvador, Guatemala, or Honduras, and you have a child that you've been wanting to bring into the country and you have a pending U visa application, or you have a pending asylum case, then you are now allowed to petition for your child to join you through the Central American Minors Program, which is at first people were kind of criticizing the program because it was too narrow of a definition of the parents that were allowed to petition for their children. But now with these updated, expanded definitions of who's allowed to petition, it allows for many more parents to have access to a program that can help bring their child into the country.
Awesome. Thanks. If you have questions about that, we're happy to answer them in the chat. Jennifer, what you wanted to talk about expansions of TPS that are happening this week?
Yes. So about a month ago, May 22nd, the Secretary of Homeland Security, Mayorkas, announced a new 18-month designation of TPS for Haiti. TPS is temporary protected status. And for a little background on that, so TPS had already been designated for Haiti in 2010 after a really big earthquake that happened in the country. And that had been extended for a while. And then in 2018, it was announced that it was terminated. And a lot of lawsuits challenged that. And during that time, it kept being extended for people who already had TPS, but people who didn't already have TPS could not apply for it. And so now with this new announcement, people can apply under the new designation. It's called registering. And the information about that is available on the USCIS website, the Department of Homeland Security website. And yeah, so that's kind of the update. If you know anyone has questions or needs a consultation for TPS, obviously they can reach out with more questions.
And by the way, anytime any of you want individualized consults on any of this, please feel free to reach out to our office. Our phone number is 303-297-9171, or you can email any of us, Ryland, Jeff, Aaron, or Jennifer at immigrationissues.com. And we'd be happy to set you up for a consult. Aaron, what's any news out of the Supreme Court this week?
Yeah, there was a big case called Borden v. United States, and it was about, it's actually not an immigration case, but it has big effects on immigration cases. So I wanted to talk about the implications, particularly for one of the most common crimes in Colorado. So kind of to set it up, a conviction for a crime can make a person, a non-citizen, deportable, or can disqualify them for relief. And one of the most common convictions here in Colorado is third-degree assault, which to be convicted, you have to knowingly or recklessly cause injury to another person. And so the way that it works in immigration is to decide whether it triggers around a ground of deportability, you take the least culpable conduct and do the analysis from there. So in this case, third-degree assault is recklessly causing any injury, however slight, so any infliction of pain, even if it's just a little pinch, that's enough for a conviction for third-degree assault. Well, this has been a statute that's been litigated for years, over decades really, in Colorado about what the immigration consequences are for a conviction for inflicting any injury, however slight, on Colorado's third-degree assault. So the Supreme Court decision basically said that a reckless conviction cannot be considered a crime of violence. And why is that important? Because now, because Colorado third-degree assault allows for conviction on reckless conduct, it can't be considered a crime of violence for immigration purposes, which means it can't trigger the ground of removability for domestic violence. There's also a ground of removability for an aggravated felony for crime of violence. And this means that a lot of people who have this conviction won't be deportable, or if they're in deportation proceedings, they'll still qualify for some kind of relief from removal. And so it's a big case in that it makes sure that a lot of people are still eligible for an immigration benefit or to stay here in this country, even though they have this conviction for third-degree assault. So this is something that we are certainly reviewing for our current clients, but for other people out there who are non-citizens who might have this conviction or may be charged with some kind of crime, this is an important case and something that we'd want to consult with you on.
Awesome. All right. Well, I think the last topic that I wanted to talk about before we move on to questions is the sunset of the Eb-5 Regional Center program. So the Eb-5 Regional Center program was created in 1992, and it was originally designated for 5 years to sunset after 5 years. What this program does is it allows for companies, investor groups to apply to the USCIS to be designated as a regional center. And what a regional center allows is it allows for that company or organization or conglomeration of investors to then go out and solicit foreign investment into the project, right? So by soliciting foreign investors to invest in their regional center program, they get the investment that they want. And the advantage to the foreign investor is that they get a path to a green card. So there's two things that happen. First, companies have to file what's called an I-924 to be designated as a regional center with USCIS and evidence that they qualify for regional center status. The second thing is an individual investor can file what's called an I-526, showing that they've invested the requisite amount of money in the project and that through that investment, they've created jobs, 10 jobs in the United States through either direct or indirect job creation. So it's a good program. It allows for a different type of residency that may be available to people that otherwise wouldn't be able to come to the United States. This has been extended no less than 15 times since 1992. And the last time that it was extended was during the Trump administration in December 30th, 2020. He extended it for 6 months through June 30th, 2021. So here we are 6 days from the sunset, and this program is about to go away. So what are the solutions? Well, first, there's a long-term solution. There's a bill pending before Congress, and the number is Senate Bill 831. It's a bipartisan bill sponsored by Senator Grassley, a Republican from Iowa, and Senator Leahy, a Democrat from Vermont. There's a companion bill in the House as well. You know, whether or not that they're gonna get enough sponsors to pass this bill is unclear at this point. So what will happen if they don't get enough sponsors? Well, what has historically happened in the past is that the designation or the redesignation of the Eb-5 Regional Center program is attached to other must-pass legislation like spending bills or appropriation bills. So that's another possibility that may happen. The third possibility is that that date passes, June 30 passes, and the Eb-5 Regional Center program actually goes away until Congress can reenact it. I think, to be honest with you, that's the most likely scenario, is that the Eb-5 program will sunset on June 30th until some sort of must-pass bill can redesignate it. So if you have a pending I-924 or a pending I-526, or even a pending I-485 that's based on an underlying 526, you're going to have problems. It will be held in abeyance, or it will be adjudicated on the merits and denied if it doesn't meet the qualifications. So if you are in this situation, please feel free to reach out to our office. There's a number of things that we're considering, including litigation on this issue, because it's not just a matter of your green cards, it's a matter of potentially millions of dollars tied up in these programs that you may not be able to access. So happy to help you out on that as well. All right, anything before we go to questions, team? No? All right, let's see what we've got. And I'm sure a lot of you have questions about our litigation, which we're happy to answer as well. All right, let's go first to Egypt. How much will it take for you to respond to the motion to dismiss in the K1 Egypt lawsuit? And what is the timeline and next steps after your response?
So I'm working on the motion to dismiss. I'm not sure about how much it will take. That's to be determined, but it is due on Monday. And the next steps, Jeff, do you know more about the timeline and next steps after the response? Because I don't.
You're muted, Jeff.
Jeff, you're muted.
Sorry, you're muted.
Sorry about that. Yes, once the motion to dismiss is filed, the government has, we have 21 days to respond to that. The motion to dismiss, there's no surprises in it. It's the same arguments we're hearing in all of the same cases. So our response is a great deal of rehashing what we've already argued and won in many of the cases. So that's what will happen. And then next steps after that, the judge will rule on the motion to dismiss. And if we survive the motion to dismiss, which is likely, then it goes to final briefing, which is two things. One is discovery. There may be potential discovery about prioritization of visas, why the K-1s are not being processed, why they're not the same priority as immediate relatives. Could be potential discovery. And then there will also be what's called summary judgment, which is a motion that both parties file. And what you're arguing in those motions is that judge, assuming that all the facts are true and that we don't dispute the facts in this case, then we're entitled to win on the basis of those facts. Both parties will argue why they're entitled to win on the basis of the facts in the record. And then the judge decides. So, when that will be, it could be anywhere from a few months to, depending on the judge's docket, a long time. Obviously, if it takes a while, we can file status reports and ask for updates and everything to try and get it moving. But we don't have control over the court's docket. Anything else to add to that? All right, when should we hear about the Kinsley lawsuit? Well, a couple things on Kinsley. We have filed our motion for summary judgment or a preliminary injunction. Remember that we've talked about it before, but it's actually harder to get a preliminary injunction than a summary judgment. And backing up a minute. A preliminary injunction is preliminary, right? It's what you're saying essentially is, judge, we know that it's going to take a while to get a decision. So in the meantime, we would like this particular type of preliminary relief. To get preliminary relief, which is relief before the case is over, you have to show not only that you're likely to win the case, substantially likely to win, but you also have to show irreparable harm if it's not granted. And economic harm is often not enough. There has to be other harms like health or public interest, humanitarian, something like that. So it's a high burden to prove. We think we meet it in the Kinsley case, which is why we filed a motion for a preliminary injunction. But we filed in the alternative a motion for summary judgment, which is what we talked about before. Based on these facts, we think we win. To get a summary judgment, we only have to show that we win. We don't have to show irreparable harm. So the standard is actually lower for summary judgment. Yesterday, we received the government's cross motion for summary judgment and their motion to dismiss. Their motion to dismiss is the same arguments we've been hearing already. So we will respond to that motion. We will have replies to that motion, and they will have replies to our motion, and then the judge will make a decision. So we anticipate a decision on Kinsley, hopefully within 30 to 60 days. Okay. All right. Any news on the Eb-5 bill? Just talked about this. No news on passage. We don't know whether it's going to be passed or not. I think, to be honest with you, more likely that it's not going to be passed. How does that implicate you, who, if you're pending at the consulate, your case can't be adjudicated? Theoretically, the government could file a motion to dismiss because there's no legal remedy for you. If that happens, we of course will go back to court and we'll prove to the court that this happens all the time and that it ultimately gets extended and that those cases are held in abeyance in the meantime. So don't worry about that. We'll handle it if it happens. But unfortunately, if Eb-5 doesn't come back and you're an Eb-5 regional center investor, you have a problem. If you're a direct investor, not a regional and center investor, this does not affect you. This is only for regional center investments. All right, Ronald, how much dependence will be counted if my sponsor, who has a family member of 5, including me, and had already sponsored his parents 4 for tourist visa, they all have valid visas, it will count as 5 or 9? Who wants to take this one?
Well, I'm not really sure that I know the technical answer off the top of my head, but what I can say is what they're looking for as far as sponsorship for a tourist visa is just evidence that the applicant can take care of themselves and house themselves and feed themselves during any visit. And so to the extent that the person filing the sponsorship paper has a lot of other people who are already dependents and are also being cared for, that it'll be taken into account. Jeff or Jennifer or Rylan, I don't know if you have anything else to add there.
I mean, the only thing I would add is you're correct, Ronald. If you're applying for a tourist visa, you're not filing it on an I-864. Mm-hmm. The I-864 is for immigrant visas, right? It's for people who are immigrating permanently to the country. It's a legally binding document. It is good. It's valid for 10 years. It survives divorce. It survives death. It can't be terminated, and the government can sue you on the basis of that I-864. The I-134 is different. The I-134 is not a legally binding document. You do sign it under penalty of perjury, but it's not legally binding. In other words, the government can't come after you for violation of the I-134. The I-134 is really just a way of organizing the information that the consulate needs to make a determination that you're not likely to become a public charge if you enter on a tourist visa. So generally, you have to show two things to get a tourist visa. Number one, you have to show that you have bona fide non-immigrant intent, meaning that you're just going to come here and visit and that you're going to go back home when you get that tourist visa. So the way you get that is to show connections to your home country, right? You have family there. You own your residence there. You're returning to a job there. You have a retirement or a pension account there. You have a lot of money in the bank there. Tons of connections to your home country is how you show non-immigrant intent. The second thing you have to show is that you have the financial capability of sponsoring yourself when you go to the country. And that's where the I-134 comes in. It allows you to take your financial information, like your tax returns, your asset statements, and whatever you want to put in, and organize it in a way that makes sense for the consulate to show that you don't have, that you do have the ability to sponsor yourself when you come in. With regard to your specific legal question, there's a difference then between if this is talking about sponsoring somebody for immigrant visa, that would only be 5 people, okay? Because the person that is going to be your sponsor has previously sponsored 5 people on an immigrant visa. That has to be counted on the new immigrant visa. But if this is just for a tourist visa, it doesn't matter. It's a new application and you only include yourself. Okay. All right, K1 Brazil, Penn v. Blinken, what's the timeline for our response? They want it to be good, so make sure we take all the time we need, by the way, James. Thanks, James.
Okay, so I'll take that one. So that response is actually due on the 6th, since the 5th is Independence Day observed. And so we'll have it filed on or before the 6th.
Yeah, and again, I wish I could tell you that the government, that we're in trouble and we have like a lot of research and work to do. We don't. Their brief is very similar to the other briefs that we've already drafted. So they're making the same arguments, nothing surprising. So our brief is really, really good. And I've said it before, I think that our response in Kinsley, which is what we're using as kind of the model for all these, is probably the best piece of writing that's ever come out of our office. It is succinct, precise. It's very good. So very proud of it. All right. Why did the UK cancel their visa appointments from August to October? What are people in the US on an H1B with no stamp supposed to do? Keep waiting? Well, I'll take this. So we know that even pre-COVID, the UK had staffing issues at the consulate. And that had to do with the turnover after the administration and other factors. So there were staffing issues before, and then COVID happened, and it was sort of a perfect storm. So what we understand is that it's as simple as not having the staff to process cases. That being said, they are processing cases. They're issuing visas, they're granting visas, and so what the issue that we're challenging and that we're fighting about is the priority for setting those visas, not only within a category in terms of like, why is this person get an interview before I do, but also why do they prioritize certain visa categories over other? So what are you supposed to do if you have an H1B with no stamp? You either convince them that you can qualify for a national interest exception, or you convince them that you're going to quarantine in a country for 14 days before you enter the US. But those are really your only two options to get into the country. Or the bans get lifted, which we've heard rumors that that's supposed to happen today. If it doesn't happen today, file lawsuits, join in the lawsuits. All right, Aaron, you knew it'd come. We have a go question. Since our case and Curtis's cases are different in nature, can the judge decide both cases at the same time? And maybe, Aaron, you can give them a little update about the class definition here.
Sure. So there are a number of different cases challenging the government's administration of the DV 2021 case, including our case called GO on behalf of our plaintiffs. And then the Curtis he refers to is Curtis Morrison, who represents DV 2021 cases in at least 3 different cases around the country, I think. I believe the one Ronald's referring to is probably the Yacoub case in the Northern District of California, where they've actually filed a motion for class certification. That motion or the proposed class in that motion actually excludes plaintiffs in other cases in the District of Columbia, which includes our GO plaintiffs. So there's nothing to stop Judge Mehta, who's presiding over the GO case, from making a decision. There's no chance, at least as the class is proposed, that any decision out of the Northern District of California will impact GO plaintiffs, and none of the other cases are proposed as classes. And so there's no impediment to Judge Mehta making this decision as soon as possible. He can do it as soon as he's ready.
What happens if a plaintiff in either case, let's say, because good luck, the other case that's pending in DC that's Morrison's has, I think, 11,000 plaintiffs? What happens if those plaintiffs or plaintiffs in GO want to be members of the class?
Well, that's going to be really interesting because, first of all, it's just a proposed class in a motion for class certification. So Judge Chen, who's presiding over that case in California, is going to probably, look at the proposed class and see whether he thinks it makes.
You froze there.
However he sees fit. And can you hear me now?
Yeah, you're back.
Okay. I was saying that the Judge Chen, if he certifies a class, which hasn't been done yet, he can craft it however he sees fit. He doesn't have to stick to the proposed class by the attorneys. And so he could craft it so that people could elect in, even if they are plaintiffs in other litigation. But as is, if he just certifies the class as proposed, then GO plaintiffs would not be able to be in it unless they were dismissed from GO, I suppose. But we would actually have to wait to see how Judge Chen handles it to make any real declarations about what it means for GO plaintiffs. So for now, it's a proposed class. It doesn't include our plaintiffs. And so to me, that's good. Judge Mehta can make the decision without even considering what's going on in the other courts.
All right. Abdelwahed v. Blinken. Does negotiation with the government stop, or could we have appointments earlier? Great question, Abadir. So we were having negotiations with the government. They reached out to us on Wednesday, yesterday, and or Tuesday. It was Tuesday, and said, all of your plaintiffs have been scheduled for interview, and one of them has been issued a visa. So we think the case is moot. Will you agree to voluntarily dismiss? And I responded and said, we're very grateful that our plaintiffs have been scheduled for an interview. We appreciate it. On the other hand, they're also screaming at me because their interviews are not scheduled for 90 days. And it seems unreasonable that a case that's already delayed has to be delayed for another 90 days. So we would have an agreement if you would get the consulate to agree to schedule them within 30 days. And I didn't hear an answer overnight. And yesterday morning, I got a very abrupt response that said, we do not have a deal. We'll be filing our motion to dismiss on Monday. So that's where we are. Negotiations are over. They're proceeding with litigation. They're filing a motion to dismiss on Monday. We'll have 21 days to respond to that motion to dismiss, and we will go to summary judgment at that point. Okay. Another question from James. He wanted a redacted copy of the Penn suit. Jennifer, Caden's working on that, right?
Yes, correct.
Okay. And we were
Yes.
close to finished.
Yes.
Yeah. So I would say today or tomorrow we should be able to get that out to the public, James. When do we expect to file the K1 London mandamus? I can tell you that I reviewed the brief yesterday, the complaint yesterday. I know that Chuck Cook reviewed it yesterday. So it is in final stages, and I would anticipate that we will file it this week, which means essentially today or tomorrow. I don't know what that is. We'll move on to the next one. Go plaintiff here. Embassy isn't replying even after we mailed that we are go plaintiffs.
Yeah, so I mean, we always tell our plaintiffs they're free to let the KCC or the embassy know that they're go plaintiffs in their communications. It's a good thing to do. It doesn't guarantee that you'll get a response at all, or even a favorable response if you get one. But that's why we've sued, because the Department of State is not responsive and not administering the DB 2021 program in good faith. And so the fact that you've reached out and contacted them is good. Keep that for your records. If we need records of that for any filing, we'll let you know.
Another good case here, Jennifer, this is for you and Ryland on Abdul Wahed, but there's plaintiffs that have documentarily qualified dates in June, but they didn't get their interviews scheduled till September. Meanwhile, there are non-plaintiffs that were documentarily qualified in June that are scheduled in July. The question is, are they penalizing plaintiffs for suing them? They're not. It's apparent that they're not going in order.
So my gut answer to this, and I saw this email actually from Mena earlier this morning, and I just hadn't gotten the chance to reply to you, but I'm glad you're here now so we can talk about it. But my gut response to this is I was just attending the AILA conference 2 weeks ago or so, and Jesse Bless, who used to work for the U.S. Attorney's Office, he was talking about the idea that that there would be retaliation against plaintiffs that sued the government, and he said that is not the case. Like from his own experience in the office, they want to get the cases off of their plate. They're not interested in retaliating, and so I don't believe that any of this would be a cause of retaliation. In fact, as Jeff was just talking about, they contacted us and they said, hey, we have all your plaintiffs scheduled for September. Would you be willing to drop the suit now? So they want to get it off their plate just like we do. But so the fact that non-plaintiffs from June were scheduled for July, it may not make sense, but I would not believe it's any sort of retaliation.
I think that's 100% right, Ryland. I've heard that from other former government attorneys as well. I think it's on the contrary. They sort of treat you with kid gloves if you litigate. Because why? Because there's the specter of attorney's fees out there, right? If they misbehave, if the government misbehaves in litigation or retaliates and there's proof of it, then it's bad faith, and we can go after attorney's fees. If you win litigation, in other words, we take a case through summary judgment and we win, and we can show that the position of the government is not substantially justified, then we can go for attorney's fees. So, the government is unlikely to do things like retaliate against you because there's penalties for doing that. So I agree with Ryland. I don't think that's the case. What is important, however, Mena, is that you're right. They're not going first in, first out. And that's important because one of the defenses that they make in all of their motions to dismiss is that it's unfair for people to go to the front of the line just because they file a lawsuit. And our argument is, show us the damn line. There is no line, right? Until you can show us a line and show us where you are on the line, stop complaining about the line. And we know that if that line exists, you're not following it because we have plaintiffs that were documentarily qualified at the same time and have not been scheduled till September. So these arguments are rebuttal arguments that we can use against their first in, first out nonsense. Okay, thank you. All right, another one on Go. Let's see, they've sent out, oh, I'm sorry, I missed this one here. Any chance that somebody from Nepal will be adjudicated, that Go will be adjudicated by September 1st?
Sure. The hearing on the motions for summary judgment is July 13th, so we could have a decision anytime after that. Judge Mehta is well aware of the September 30th deadline, and we would hope that there would be a decision before then.
Yeah, I mean, in an ideal world, he'll issue a decision right away, right? Quickly after July 13th, which gives you full 2 months, the consulate's full 2 months before September 30th to adjudicate your visas. Here's the other thing we know. Joe Carilli, the attorney on the other side, reached out to us, I don't know, 3 weeks ago, maybe a month ago, and asked for a spreadsheet with all of your identifying information. Why would they do that? Well, because they also are aware, they're looking towards the future too, and they're aware that if we win this case, they're only going to have 60 days to adjudicate, what, thousands of visas? So that's why they asked for the information, because they're getting ahead of it just in case. So the answer is yes, we think that you'll be adjudicated quickly. If you're not, that's why we're asking the judge for an alternative form of relief to reserve visas, because if the consulate can't do their job, then it's unfair that the visas go away. So, that's the alternate form of relief that we're asking. Okay, another Go one. They sent out their documents March 19th, got a reply from KCC. On the recent impact litigation, Cook said that we should send documents to KCC. Just want to clarify if you should send the documents one more time.
I don't understand if the question is to send them again if you've already sent them, or to clarify that you should send them. Yes, you should absolutely have sent all your documents to KCC.
And then the question is, having sent them back in March, should they send them again?
Frankly, I don't think it hurts.
Yeah, I mean, I don't think there's a right answer or a wrong answer. Your front, you keep sending it to them may, in fact, put you back to the front of mind. And I'm not encouraging everyone to resend their documents. That's not what I'm saying. I'm just saying that it's one of the ways to get your case back on track, in addition to reaching out and sending emails. Okay, reservation of visas. If the lawsuits ask for reservation of visas, will judges not just point out between the lawsuits saying the other lawsuit will reserve visas? In other words, will one judge slough off reserving visas because the other judge is going to?
Well, for example, in Go, it's not a class action. And so while we ask for the reservation of all 55,000 available visas, another option for the judge is to reserve visas for the number of our plaintiffs and their derivatives, in which case there would be no need to look towards any of the other lawsuits. So there are options between the judges. They're all aware of the other cases, and I can't really predict what that interaction will be. But there are options that preserve our plaintiffs' rights, and that's what we'll be pushing for.
And it's really impossible to answer that question because, let's say there's 5 different lawsuits that are going on around the country, and one of those lawsuits is decided. And that decision, whether or not it's a class action, basically says, Department of State, you have to issue in good faith all these visas by September 30th, right? The problem with that is, number one, the government can appeal that decision to the circuit court. When they appeal it, they can file a stay of the judge's order while they appeal it. So, that would mean that there's no order in place that's binding anywhere, right? Or the judge could just issue a decision that's only to the named plaintiffs, which we've seen happen before. Which would, even if it's a class action lawsuit, the judge could say the relief I'm giving is only for named plaintiffs. I'm not going to give nationwide relief. So it's so impossible to tell you what impact one case will have on another, because it's really just sort of it depends on what happens step by step. So I wish we could give you a better answer, but it's really impossible. All right, in Penn v. Blinken, was the government supposed to respond by tomorrow, or have they already responded?
They responded. They filed their motion to dismiss Monday.
So when is our brief due on that one, Jennifer?
That's due on the 6th.
Yeah, so yes, we have it. The motion to dismiss, we're working on our response right now. Okay. Some of these we've already done. Another somebody wants to update on Penn, update on Go. Here's one on Milligan. It would appear that Milligan round 2 hangs on the success of Ramirez. Given that, and as a courtesy, would it be possible to look at the pleadings, including the administrative record for both cases? Not the administrative record, because it's voluminous. But yes, we can absolutely share the pleadings for Manila and Ramirez. We need to redact them. I think we have the Milligan pleadings out there. The Milligan pleadings are already posted and redacted. But yes, we can do that for Ramirez. That's not a problem. And I think that may be all the questions we have. Anything final that you all want to talk about before we move on?
No, just thanks everybody for tuning in and giving us your questions, and we will be here again next week.
As always, if anything we talk about is something that may impact you, or if you just want a legal immigration checkup, that's what we're here for. Call our office at 303-297-9171 or email any of us with our first name at Immigration Issues, and we'll get you scheduled for a consult and see if there's anything we can do to help you out and get you on the path to regularization. So thank you for tuning in, and we'll see you next week at 12 o'clock Mountain Time, 2 o'clock Eastern. Thanks, everybody.
Thank you.